Now we're going to talk about aggravating factors. These are not elements of a crime, but these are things that might be present that increase the severity of a particular crime and therefore its penalty. And of course, this only would apply to crimes where there are multiple degrees or levels. For example, disorderly conduct only has one level of seriousness. But larceny has many levels of seriousness, often determined by factors like the value of the property, more valuable property being more serious to steal. So, let's talk about these aggravating factors. The first would be the mental state of the person committing the act. It is more serious. It is a more serious form of assault to intentionally injure someone than to do so recklessly. Because when you do it intentionally, you want it to happen. When you do it recklessly, you had no intention of injuring somebody, but you engaged in unjustified, dangerous behavior that did so. Not as blameworthy as wanting to do it and doing it. Another aggravating factor would be a factor relating to the victim. It is a more serious form of rape to have non-consensual sex with a 10-year-old than with a 17-year-old. And it's even more serious to have non-consensual sex with a 6-year-old. So that's a factor related to the victim, that you're the person victimizing. There are also factors related to the defendant that can increase the seriousness of a crime. Having sexual relations with the person you have a supervisory relationship with, like a teacher or corrections officer having sex with a student or an inmate, that's an aggravating factor. So if a teacher were to have sex with another adult consensually, there would be no crime. But if they did it with a student, that would be a crime because of the supervisory relationship. So that's an example of a factor related to the defendant. Their position that they're abusing, their power position, would make it a more serious crime. And there are also factors related to the circumstances of the crime that can aggravate or make the punishment and the criminal level more serious. For example, it is more serious to commit a residential burglary at night than a residential burglary in the daytime. Because nighttime is considered more dangerous and spooky, and we want to penalize people who break into houses at night more than those who do it in the daytime. It's more serious to assault someone using a weapon than your bare hands. That's the difference between armed assault and strong arm assault. Even when the same injury is caused, it's more, in addition, it's also more serious to possess a kilo of heroin than an ounce of heroin. So those are all factors related to the crime itself that make the crime more serious based upon, again, things like the time, if it's a burglary, whether you use a weapon or your hands if it's an assault, or in most drug cases, the more drugs you possess, the more serious the charge. These are all aggravating factors. Okay, now we're going to talk about the classifications of offenses, the way we organize them. Now, offenses are any violation of the law, and they can be classified as violations, also called infractions, misdemeanors, or felonies. So again, any violation of a law is an offense, and offenses are then divided into violations, misdemeanors, or felonies. Let's talk about violations first. Violations are minor offenses, and they usually only involve a fine. But if the defendant repeatedly commits the offense, he or she could, for some violations, be sentenced for up to 15 days in jail. This provision of occasionally sending people for these minor violations to jail is designed for offenders who view breaking a minor law a cost of doing business. This might be a pushcart vendor who finds it easier to pay an occasional $75 fine as opposed to having the much higher licensing and inspection fee requirements. So if an offender stubbornly keeps committing the minor offense to avoid paying licensing fees, for instance, the judge can say, all right, if the small fines aren't deterring you and making you get your license, now you're going to go to jail for 5 days, and then when you get out, you can do the right thing. So those are violations, also called infractions, and they are minor violations of the law, generally only entailing a fine, but in some special cases, a little bit of jail time. The next classification are misdemeanors. Misdemeanors are less serious offenses, but can involve jail time, 1 year or less, and substantial fines. In addition, technically being convicted or pleading guilty to a misdemeanor labels one a criminal, because felonies and misdemeanors are called crimes. Violations, while in the criminal law, are not technically crimes. But in practice, one only has a criminal record if the misdemeanor one was arrested for resulted in being fingerprinted, a printable offense. One of the problems is that many local jurisdictions make very petty offenses misdemeanors as a deterrent. But this over-criminalization of offenses is a problem because it creates criminals who do not deserve the label criminal. To give you an example, in my own town, Fountain Hills, I was shocked to discover that carrying a glass container in our parks was a misdemeanor, like a soda bottle. They don't want people to carry glass containers in parks because if they fall and hit the sidewalk, they'll break and kids will get cut on them. So it's illegal. But instead of making it a violation, because it's a very petty thing, my particular town and many others made it a misdemeanor, thinking that that would really deter people. That's called over-criminalization, and it's stupid. And it was changed in Fountain Hills. But you still have this in other jurisdictions. I'm attempting to pass a state law that would make all localities reevaluate these particular penalties, but I'm having a little difficulty thus far. As you know, I'm a state senator, so I get to pass laws sometimes. The final classification are felonies. Felonies are serious crimes that can result in a prison term, and that's over a year in a state-run or federal prison. Conviction of a felony or certain felonies can have other consequences, like loss of voting rights, a ban on weapons possession, disqualification from receiving certain career licenses, and for some sex offenders, lifestyle restrictions and having one's name or address placed on a sex offender registry. So to recap, you have minor offenses, which are called violations or infractions. They generally only involve a fine, except in unusual situations. Then one step up are the misdemeanors. These are less serious offenses, but they can involve jail time or a year or less in a local jail and some fines. And then finally you have felonies, the more serious crimes that can result in a prison term. And that's going to be over a year, and instead of being in a local jail, you're in a state-run prison or a federal prison if it's a federal offense. And the conviction of a felony can also have a fine and certain consequences like losing voting rights, weapons possession, etc. So those are the classifications of offenses: violations, misdemeanors, felonies, in that order, increasing order of seriousness. Now let's talk about the purposes of punishment. When legislators pass laws, criminal laws, and they assign penalties, they have to decide how serious and what type of penalty to apply. And they should be guided by what they think the purpose or purposes of the punishment that they're imposing should have. So there are 6 purposes of punishment. The first one is deterrence, making people less likely to commit criminal acts for fear of punishment. Deterrence works best when the chances of apprehension are great and the punishment is delivered swiftly. This is a common rationale for punishment. We want to deter people from committing crimes. Now, there are 2 types of deterrence. Deterrence can be specific, and that's when it's aimed at making the person punished not recidivate or reoffend. So if we put a harsh penalty on a particular crime, it's designed to make the person who committed it and is being sentenced to teach them a lesson so they don't do it again, so they don't recidivate or reoffend. But there's also the concept of general deterrence. And that's when you make an example out of the offender So others will be deterred from doing the same thing. So you have a serious punishment for somebody who commits a crime, and you make sure everybody learns about that. So they say, wow, I don't want that to happen to me. I'm not going to commit that crime. That's general deterrence. Now, another purpose or rationale for punishment is incapacitation. That's removing the person from society, usually by incarcerating them, so they cannot harm others by their criminal acts. Incapacitation usually involves identifying persons at high risk of reoffending using certain factors like the number of prior arrests, the age at their first offense, etc. High-risk criminals are given the maximum sentence to keep them incapacitated in prison, away from the rest of us so they can't harm us. And this is especially during their crime-prone years, which tend to be the ages of 18 to 30. So if you had a juvenile, say 19, 20 years old, who committed an armed robbery, and the records check reveals that they committed their first robbery when they were 15, and they've done one or two since then, this would be a person who is a high risk of reoffending offender and would be a target for incapacitation, throwing the book at them, giving them the maximum sentence so they don't get out until they're well beyond 30 and less likely to offend, because older people commit less crime. Another purpose of punishment is rehabilitation. Rehabilitation is curing the offender. Rehabilitation is based upon a medical model of criminology that believes that criminals are sick and they can be cured. It is not especially effective for two reasons. First, people, especially adults, are very hard to change. And second, these rehabilitation programs are usually underfunded, so they're not particularly adequate. But rehabilitation is a noble purpose of punishment, but one that is not that effective for the reasons I spoke to, and usually doesn't work. So those are the first three purposes of punishment, but there are more. The final three purposes of punishment are retribution, restitution, and restoration. Let's talk about retribution. This involves society, especially the victims, getting revenge. Restitution is an age-old purpose for punishment, and it's best phrased in the historic biblical phrase, an eye for an eye, a tooth for a tooth, a son for a son. So it involves society, especially victims, getting revenge and ensuring that the offender gets his or her just deserts. Because retribution is also called just deserts. It is a philosophy that says if you do an act, you deserve punishment. If the act is very bad, the punishment should be very bad. If the act is minor, the punishment should be minor. That's called proportionality. Another purpose of punishment is restitution. Having the criminal make the victim and or the government whole by paying monies to them as compensation for the harm done, the loss, and the cost of the crime. A victim is made whole when given money that compensates them for the harm the criminal did to them in the way of lost income, medical expenses if they were injured, property replacement, damaged property. The government is made whole when the criminal pays for some or all of the court and incarceration costs, and that's called restitution. And that usually involves payments, either to the government as fines or to the victim as restitution. The final purpose of punishment is restoration. This involves returning all parties to their pre-crime condition by the offender accepting responsibility for the criminal act, making restitution to all the harmed parties, and paying other expenses, and reconciling with the victim and society. It is embraced by people of the liberal political persuasion, and it is more effective with less serious transgressions, like simple assault, theft, or property damage. It is not used that much, certainly not for serious crimes where a rape victim would not want to see the perpetrator. This particular purpose of punishment was not mentioned in your textbook, but it is a purpose that you will occasionally hear about, and that it does occur in some jurisdictions. In terms of these 6 purposes of punishment, keep in mind the dominant philosophies in the United States today are retribution, revenge, and incapacitation. Don't let them harm us. So far we've been talking a lot about laws, but we haven't delved into where do laws come from? What are the sources of law? And law comes from 3 places: the U.S. and state constitutions, federal and state statutes, administrative agencies, counties, cities, and towns, and case law from courts. The federal and state constitutions are the highest sources of law, with the U.S. Constitution being superior and overriding all other sources of law in the country, including state constitutions. Constitutions mostly create and define the government entities they preside over. They also protect rights, but they also may contain certain criminal statutes. For example, the federal Constitution has the crime of treason. Another source of law, federal and state statutes. These are laws passed by their respective legislative bodies, for the federal government, Congress, and for states, the legislatures, by majority vote, 50%, well, plus 1. These legislative bodies generally have 2 chambers, a Senate and a House, although in some states they're called, assemblies, and each must pass the proposed law or the budget in the same exact form. It then must be signed by the chief executive, the President of the United States, or if it's a governor, the state governor. If the executive refuses to sign the law, it can only be enacted by 2/3 vote of each legislative body. In some states, citizens can create a law by voting for it on election day through the process of referral. The legislature votes to put that on the ballot for the people to vote on, or initiative. Citizens, on their own, collect enough signatures from voters on petitions, and if they get enough, it goes on the ballot to be voted on. So those are some of the sources of law. But again, there are more. Administrative agencies, counties, cities, and towns can pass laws, so long as they do not violate the U.S. Constitution and their respective state constitutions, and the legislature of that particular state has not preempted local governments from passing legislation in that particular area. Administrative agencies are generally executive branch agencies under the president or governor that have been given authority by the legislature in a law signed by the chief executive to pass regulations or laws that can sometimes have criminal penalties. Examples of such administrative agencies include the Internal Revenue Service, the Federal Communications Commission, Federal Trade Commission, and others. So again, if the legislature passed a law that was signed by the chief executive that grants an administrative agency in that level of government the authority to pass regulations that have criminal penalties, then an administrative agency can be the source of a criminal law. Likewise, counties, cities, and towns are governmental units set up and empowered by state constitutions to govern locally. They are run by their own elected bodies: county supervisors, county freeholders, councilmen, councilwomen, aldermen, aldermen and women. These are all the different titles for your county and local governments. These local government entities can generally only pass laws, penal statutes, that are violations or misdemeanors, and in areas related to health, safety, and welfare at the local level: littering, animal control, noise, building code violations. So those are the different sources of law that we have in the United States. The final source of law is case law. Case law consists of the collective rulings of courts as they rule on the facts of particular laws, which involves interpreting their meaning. And this usually occurs when the legislature wrote the law with some ambiguity, some confusion, vagueness. Case law has its origins in English common law, where it was the most dominant form of law and was rooted in tradition and custom. English judges followed previous judicial decisions by other judges for consistency. This is called precedent, or stare decisis. And this consistency, these continuous rulings, strengthened case law. Case law, therefore, is often called judge-made law. Here's a definition. Case law is reported decisions of appeals courts and other courts which make new interpretations of the law and therefore can be cited as precedents. These interpretations are distinguished from statutory law, which is the statutes and codes enacted by legislative bodies. Regulatory law, which is regulations required by agencies based on statutes, and in some states, the common law, which is the generally accepted law carried down from England. So again, you can read the rest of that definition. But case law is judge-made law. It used to involve making almost new laws in new areas. But today, we are primarily a country that is based upon statutory law. So most of the case law today consists of judges making rulings to deal with ambiguity in the statute. When the legislature didn't write it clearly, the judges have to try to figure out what did those legislators mean. And that becomes a ruling that other courts, in some cases, have to rely upon. So that's case law. And that concludes Lesson 1. We'll now move on to Lesson 2.